Good afternoon, everyone. We want to welcome you to the Child Protection and Advocacy section's Lunch and Learn CLE. Today, we have a very interesting CLE entitled Legal Advocacy for LGBTQ plus Youth in Child Welfare and Juvenile Justice Settings. Just a little bit of housekeeping. This CLE has been approved for 1.5 general credit hours. If you have any questions, the chat will be disabled, but please feel free to include your questions in the Q&A. I will be monitoring that, and we will stop midstream in between, and we'll make sure that we try to have your answers presented to both of our co-presenters today. I'm going to allow them to introduce themselves without further ado. Mr. Curry Cook and Ms. Shruti Swaminathan.
Hi, thanks so much, everyone. My name is Curry Cook, and I use he, him pronouns, and I'm a senior counsel with Lambda Legal and direct the Youth and Out-of-Home Care Project at Lambda, which we'll tell you a little bit more about later. And actually based out of our New York office. I live in Brooklyn, but I actually grew up in Georgia. I was born in Athens. I grew up on a farm outside of Georgia, and went to UGA for undergrad because my dad worked for UGA, so I didn't have much choice. And also went to Mercer University for law school. Just a bit about my background as it relates to this. Prior to joining Lambda Legal and focusing on advocacy for LGBTQ plus youth in out-of-home systems of care nationwide, I represented young people in both juvenile delinquency cases and child welfare cases in Alaska, New Jersey, and here in New York, where I live now. And now I do a mix of litigation, which we'll talk a little bit about at the federal level, and then also a whole lot of proactive law and policy development at the state level around youth and out-of-home care. And then we do a lot of education and trainings like this one, particularly for attorneys for children across the country. So I'll turn it over to Shruti.
Hi, everyone. My name is Shruti Swaminathan, and I use they, them, or she, her pronouns, and I'm a staff attorney at Lambda focused on LGBTQ plus youth. And so, as Carrie mentioned, my work also consists of litigation, public policy, and public education efforts in order to protect and advance the rights of youth in all aspects of their lives. Our advocacy encompasses, LGBTQ plus youth in schools, youth in out-of-home care. We also work on LGBTQ issues in other ways, such as advocacy for undocumented youth and advocacy on behalf of youth who've been trafficked and or sexually exploited. And so it's a comprehensive approach to our work on behalf of LGBTQ plus youth. Before joining Lambda, I spent 4 years in the litigation department of Wilkie Farr, a New York-based law firm. And there I had the opportunity to engage and work on behalf of the LGBTQ community and undocumented folks. And I am also based in the headquarters of Lambda's office in New York and also live in Brooklyn. Not from Georgia, but I love Georgia. So happy to be here with all of you.
And I just want to say thank you so much to Anissa and also to the Georgia Bar for putting on this topic and really having it front and center. And we'll explain a little bit about the research and the data and like why all this is important. But I just want to acknowledge that like we're in a situation now where because of thankfully a real increase in broader societal messages around acceptance and young people really being able to be themselves writ large, that hasn't necessarily meant that in the microclimates they're in or in their placements in out-of-home care or in these government systems of care that it has been welcoming. And we are still faced with the reality of systems of care that are, at least in theory, designed to help young people are often perpetrating more harm on them, and where that puts young people and being really brave and being out, but then still facing a lot of mistreatment and harm when they shouldn't, and when that's harmful to their well-being. So thank you for putting this topic front and center. And we'll just dive right in. And I've been accused of talking a lot faster than I used to since I moved to New York City. But today we're going to be intentionally talking really quickly because we have a lot of content to get through with you, but we are going to pause midstream as Anissa said for questions, and then we'll pause again at the end. So hopefully we'll have some time to get at what you want to know and find helpful or any questions you have based on the content. So we'll dive right in. So we're just going to tell you just a bit real quickly about Lambda Legal as an organization. If you're not familiar, then go into a little overview of sexual orientation, gender identity, and gender expression as concepts, so we're all on the same page. Then talk specifically about LGBTQ plus youth in child welfare and juvenile justice settings, some of the data that we know, what we don't know, what some of the common challenges are for youth in these systems. Then we're going to give some tips about zealous advocacy. I know all of you may not necessarily be attorneys for children on the call, but that's kind of where we're coming from and being attorneys for young people. So we're going to focus on that and then talk about how that pans out in terms of sometimes other players and stakeholders in the system and their response and some things to think about. Then we're going to zero in on what I think probably a number of you have been following this year, which is just these horrible attacks on trans and non-binary youth and attempts to harm them and limit their right to be themselves. And then we're going to again take questions at the end in midstream. So I'm going to, we did introductions. I'm going to tell you about Lambda Legal. If you don't know, we're the oldest national legal organization that's committed to achieving full recognition of the rights of LGBTQ people and everyone living with HIV. As we said, we do impact litigation, education, and public policy work. We have had an office in Atlanta for many years, and some of you may have interacted with our wonderful colleagues in our Atlanta office. So we really cover sort of all aspects of defending identities and relationships, working hard to strengthen and defend when they're under attack, non-discrimination protections, demanding policies that are driven by science and not stigma. And then a piece of what we're doing here today is thinking about bias as it sometimes appears explicitly or implicitly in justice systems. We have a help desk line, so whether it's a young person or adult or what aspects of their life they may be experiencing discrimination or mistreatment, and they are someone who's living with HIV or LGBTQ, please call our help desk line, and we will be able to assist either with a referral or looking at whether it may be an impact type case for us to take on. So I'm going to turn it over to Swathi, who's going to do a little bit of an overview around sexual orientation, gender identity, and gender expression.
So I think in working with LGBTQ plus folks and all folks, terminology is important, and affirming and respecting someone's identity is important. So we just wanted to give a brief overview of the terms that are most commonly associated when talking about a young LGBTQ person's identity. And so as you can see from the slide, sexual orientation, gender identity, and gender expression are three distinct concepts. It's important to understand each individually to best understand all your clients, but especially your LGBTQ plus clients. And so as a high-level overview, sexual orientation is one's attraction to another person, including both physical and emotional attraction. Gender identity is one's personal understanding and experience of being male, female, both, or neither. It's important to note that gender identity may not always match a person's sex assigned at birth, which is either male, female, or intersex. And sex assigned at birth is derived solely by a doctor's determination made on a baby's body. So it's common for many trans and non-binary youth for their gender identity to not match their sex assigned at birth. And finally, gender expression is the way an individual expresses themselves through clothing, hairstyle, mannerisms, names, and other means, as you can see on the slide. And it's important to note that gender expression is self-chosen. And so in determining identity or understanding a young person's full identity, you don't want to conflate these three terms as they have distinct meanings. And it's best to let a young person identify themselves with respect to all three when you're working with them. So next slide. So as I mentioned, when working with LGBTQ plus youth, it's important to understand how they identify, and there are best practices with respect to doing so. First and foremost, the young person knows their identity best. So it's important to allow the young person to self-identify when they're ready. And when they do start sharing information with you about their identity, to mirror the language that they use to describe their identity. Terminology and identity is very fluid and ever changing these days. So a young person may not use the same pronouns that they used in the prior meeting you had with them in your second or third meeting with them. It's always important to ask questions in a respectful way that helps you understand what the terminology or language they use means to them. So if their pronouns do change throughout their interactions with you, it's important to understand how and why their view of themselves is changing and how you can best support them. So adjust your language if and when a youth's identity or expression shifts. Language, identity, and expression are fluid, especially for adolescents. So it's important to just, be respectful and ask questions when you have them, and to clarify how they identify themselves throughout your interactions with them, to make sure that you are affirming them to the best of your ability as their attorney. And we will be talking about incorporating a more proactive conversation about your client's identity later in the presentation today, so you have an example of how this may play out with your clients in particular.
Thank you. Yeah, I think always a great thing to think about too is, if clients are disclosing to you their identity, to really just be prepared and think, like, a great thing to say right off the bat is just, thank you so much for sharing that with me. I really appreciate you trusting me with that information. And then you can have a conversation about confidentiality and other things, which we'll talk about, as Shruti mentioned, a little bit later, but having a go-to, really let them know immediately that you appreciate them sharing and thank you. And as Shruti said, I think a great thing too is, if they're using a term that you're not familiar with, is to ask how they just define that, or how they describe that for themselves. And that opens up a really important conversation. Always good to be mindful though that it's not your client's responsibility to educate you about all things LGBTQ. So it doesn't get you off the hook from doing your homework, but is important because terms mean different things for different people, and really like opening up that dialogue, showing that you're curious, seeking more information is really a great thing to do, and really begins to establish that relationship and that you're a person that your client can really trust. So we're going to go ahead into, if I can get the screen to advance. There we go. Going to go ahead into talking about LGBTQ plus youth and child welfare and juvenile justice settings. So we'll start out with some data real quick, and what we do and what we don't know. So we don't have any nationwide or in any state, unfortunately, statewide data about the actual number of LGBTQ plus youth in care. And that is because we have not historically asked young people and recorded that information when they come into care. A piece of that is because of the concern historically about having young people out themselves into systems or situations that may not be safe. And also a perception that, oh, this information's none of my business. Who you quote sleep with is none of my business, and like other, I think, sort of preconceptions about whether this information is relevant or not. The field has moved considerably on that front, and recognizing that without SOGI data, that we cannot have a conversation about evidence-based practices. We cannot have a conversation about funding for services. We really can't get at anything now without data. And that young people themselves now are in a much different place about having conversations about who they are, and that it's really the adults that have a long way to go in catching up and feeling comfortable having those conversations. That said, it is really important to have explicit non-discrimination protections in place and understand confidentiality, have protocols in place so we aren't inadvertently harming young people. So with that preface about data collection generally in the context of these out-of-home care systems, Well, the information we do have is from some studies that have been done. Both of these were done recently, 2020 and 2021. One, a survey of young people in New York City foster care, where around 34% of young people identified as LGBTQ, and another one in Cuyahoga County, Ohio, which found that 32%. So you may be thinking, whoa, that is a lot of kids. So yeah, about a third of the population in care identifying as LGBTQ, which, depending on your estimates of youth in the general population, is double or even higher of an overrepresentation. And also important to understand, given what we know about systemic racism and poverty and the funneling of Black and brown children and families into care, that largely we're talking about here are LGBTQ plus youth of color who may have faced all sorts of discrimination on different aspects of their identity, separately or simultaneously. So really, I will posit to all of you on the call that, if we're not doing better by LGBTQ youth, we're failing about a third of the kids in our care, which is really appalling to think about. And while you may be thinking, well, I just don't really see these numbers, I think that may also be part and parcel of not having a truly affirming system where young people do feel comfortable disclosing and talking about who they are in the context of their care. So we also know that just being a child in the child welfare system, unfortunately and counterintuitively, increases your chance for experiencing homelessness later. And for LGBTQ youth, this experience can be on steroids or exacerbated because of the failure of systems to provide targeted services. While LGBTQ young people in care need all the same basic things that any kid in care needs, the things that we're going to be talking about today are some unique experiences that LGBTQ youth may experience before coming into care and then while in care that drive some of these disparate and disproportionately negative outcomes. So one of these is just thinking about in the child welfare context, what our permanent plans are. Of course, doing our best to prevent removal if that can be safe for the child. Always working on reunification as a primary focus, and then going down the permanency chain. So if we're not really providing targeted services around family acceptance for young people who have been rejected by their parents, and that's the reason or one of the reasons they're in care, then we're already kind of going down this slippery slope. Same goes for kin. If we're not really exploring whether a relative may, with some information and assistance, therapy, if that's appropriate, be an affirming place for a young person, then we're automatically kind of going in, for lack of a better description, stranger foster care. We know in Georgia and all across the nation that we do not have enough LGBTQ affirming foster homes, and that LGBTQ people who arguably are more likely to be affirming of LGBTQ youth are an underutilized resource. And sometimes we have gone to the same pool in the same places and are still expecting different results. And we should really expand our thinking about where and who to recruit in terms of foster homes. So if we don't have foster homes that will accept LGBTQ young people, then they end up disproportionately in congregate care or group home settings. Because those are largely sex segregated spaces, many of them have not done work to become LGBTQ affirming. That can be an unsafe place. And as I said, representing clients before, my client has voted with their feet and gotten out of a bad situation, ending up on the run, ending up in shelter placements or a 30-day cycle where there can also be safety issues. So all of this leads us down the road from a permanent home, a permanent plan, and out into exiting into homelessness, at higher rates. So at all of these points along here, we can and should be doing better, having family acceptance services, working on with kin to be an affirming place, increasing our foster pool, working with the existing foster parents on equipping them to be positive and affirming homes for LGBTQ, thinking about our congregate care places, allowing them to be trans youth placed consistent with their identities, trying to address sex segregation, really questioning whether it needs to be occurring at all, recognizing that we have non-binary youth. that may not feel comfortable or being in either place isn't authentic and true to their identity. And then really thinking about like, why do some LGBTQ youth just end up in congregate care or residential simply because there's no place for them to go, which is completely inappropriate. So all of these places are things where intervention around services, practice, and policy can really make a difference to stem that pipeline into homelessness, which some studies indicate that 50% of youth experiencing homelessness are LGBTQ. And the relationship between being in foster care and being, kicked out, abandoned, or running away due to being LGBTQ is really high, fueling some of our disproportionate numbers of youth in care. And also, back to the other slide, I think we know that oftentimes child welfare systems are sort of loath to bring a 16 or 17-year-old into care. And so some young people may be going directly from being kicked out by parents to homelessness and not being picked up by the child welfare system when they could, or others who exit the child welfare system to homelessness because of lack of permanency. The same is true in the juvenile justice system in terms of overrepresentation. This data is from a study done in California that found that around 20% of kids in juvenile justice facilities there at the time identified as LGBTQ. And you'll note that for girls, around 40% in girls' facilities identified as LGBTQ. And then I really want to note the other portion of this slide really reflecting this disproportionality in terms of race, that of the LGBTQ youth, self-identified 85% of those were youth of color. So really we're talking about this intersection of race and LGBTQ identity that's really critically important to acknowledge and address. So why do we have these high juvenile justice numbers for LGBTQ youth? Again, I think similar experiences to kids in general being funneled into the juvenile justice system, but on steroids. So we thankfully talk a lot more and are trying to address in many places the school to prison pipeline, but we also know there's a foster care to prison pipeline that if you're experiencing homelessness, your chances of coming in contact with the justice system are dramatically increased. And then there's just walking while a Black or brown person, or walking while a trans person, or walking while a trans person of color. That means you're going to have an increased likelihood of law enforcement. So if you are, say, a trans girl of color in the world and then involved in all of these systems, you could have all of these pipelines working simultaneously as a way to funnel you into the justice system. And detention facilities, even though many are trying to do better by LGBTQ youth, historically have been very dangerous places and still are for LGBTQ people. So doing whatever we possibly can to stop these pipelines into justice systems, I think is really critical for all of us, whether attorneys or whatever our role in the system, because it really does put young people at really great risk if they end up in detention or detention facilities, whether short or long term. So we talk a little bit about the challenges for LGBTQ youth in care in a few different buckets, just for simplicity purposes. One is isolation. So if you aren't actually able to share and talk about aspects of your life and your identity, that can lead to keeping those things inside. And we know that that leads to depression, suicidal ideation, all these negative public health outcomes. So creating a system where young people can be themselves is good for their well-being. And also, when we have systems that are designed, at least in theory, to have a case plan, to get at what's really going on, to address problems, to recognize strengths, to talk about, family and home and what's going on, and we don't actually know what's really going on and contributing to problems for youth, then we're often missing the boat. So both from a kid's well-being perspective and from a system trying to meet their needs perspective, really having a system where young people can be themselves and be out is good all around. So victimization, obviously just being physically assaulted, emotionally abused, all of these things can unfortunately happen in care for young people, even though the system is actually designed to help them. And I think the dissonance for a lot of clients I've worked with over the years who know that they were removed from a situation that was harmful around their identity and then are being harmed or mistreated while they're in care based on their identity is something that is not lost on them, and of course shouldn't be happening. Differential treatment are really talking about the rules applying differently to LGBTQ youth and others. A classic example is a young person in a group home being able to go out on a date or show affection to a person of a different sex, but not of the same sex. Disclosure dilemmas and confidentiality violations are related. So disclosure being for young people having to navigate whether they can come out. Is this person safe? If I disclose to my caseworker, are they going to treat me differently? If I tell my attorney, are they going to be less of an advocate for me because of who I am? These are all things that young people unfortunately still have to go through. So again, making sure that we're creating a safe space, sending messages that we're safe folks to be trusted with this information is really important. Confidentiality violations really mean sort of disclosing inappropriately to folks who don't know or don't need to know someone's sexual orientation or gender identity is really important to think about. Lack of family-centered services is a big one, as I mentioned, in thinking about what we can do to stop this pipeline into homelessness, making sure that we are always recognizing that every family has the opportunity to grow and learn and move to a place of support and affirmation, and that those targeted services really do have a lot of success. Obviously, representing clients, that's an opportunity for client counseling, and some of our clients may really not want to participate in those services because of the way they've been treated by their parents. But what we know from some of the family acceptance research is that even moving from a really highly rejecting stage to moderately rejecting improves well-being for young people. So everything that we can do to promote family acceptance as a system is really beneficial. And then the final one is a big one, lack of competence among providers. So I think you all know, hopefully for better, but sometimes just as a matter of course, we refer kids and families out for this service and that service to this provider and that provider. But really incumbent upon all of us to do our vetting. Are the providers we're sending kids to competent and working with them? Are they going to be discriminated against or mistreated? How in the world are they going to be successful at services if those services aren't supporting their basic identity and affirming who they are? Or more importantly, again, really getting at kind of what's going on with the family or with the young person related to their identity. Just some other particular challenges. We talked about lack of kin and foster placements, disproportionate use of congregate care. Another big one is just denial or delay in medically necessary care. So a recommendation or having the opportunity for young people to talk to qualified healthcare providers about whether they would like to pursue puberty blockers or pursue HRT or whatever gender affirming care they would like to have is really, really essential for young people's well-being. Like we know that trans youth in particular have really high rates of suicide and suicidal ideation, and that having the ability as a young person defines it, any kind of medical intervention that has them feel reflected in the world as they identify is really critical and improves well-being outcomes. And just like any other healthcare that's recommended by a doctor, we should be pursuing this and making sure that kids in care are seeing qualified physicians and therapists who can help them navigate this process as they would like to. And then just refusal to respect identity in all or some aspects, insisting on calling a young person by their legal name or pronouns associated with that legal name rather than who they are and pronouns that they use. It's harmful to them. Placing inconsistent with identity. If a youth wants to be placed consistent with their identity, is harmful to them. So these are all some basic challenges. So I'm going to turn it over to Shruti now to talk a little bit about talking with your clients proactively about their identity.
Yeah, thanks, Curry. So as Curry just mentioned, making sure you respect all aspects of your client's identity is incredibly important. And I think one thing that we suggest that you can do to assist in this process is to really standardize the way that you approach your work with all clients. not just your LGBTQ clients. Proactively asking about identity and experiences is a good practice for your work with all youth. But with regards to LGBTQ youth, I just wanted to run through like an example of how you can proactively ask questions about identity and minimize the amount of discomfort that you feel and your client feels. So, for example, if you meet a new client for the first time, this may be a way to start the conversation. So if I'm the attorney, I'd say, like, hi, my name is Shruti Swaminathan. I use they, them pronouns, and I'm your attorney. I see from the court papers that I received for you that Michael is your legal name. Do you identify with that name, or do you use another name? And also, what pronouns do you use? You may worry that your client will feel offended by the questions you ask or will be uncomfortable answering them. And I think a good way to quell that fear is to describe to them why you're asking these questions. For example, letting them know that when you are in care, you may experience discrimination on the basis of some aspect of your identity, whether that's your race, ethnicity, religion, gender identity, sexual orientation. And I hope you can feel comfortable sharing some of this information with me so that I can best represent you as your attorney and ensure that you do not experience this type of discrimination, or do whatever I can to minimize the chance that you will be discriminated against on the basis of some aspect of your identity. So, regardless of the fear that you may have that these questions are going to trigger an uncomfortable emotion in your client's response, I think the best practice is just to make sure that they understand why these questions are being asked of them, and to really emphasize that it's for their best interest and their safety, and to not, to not make sure that they are uncomfortable in any way with sharing information that they may not even have shared with their families or any other person, to make sure that you respect the confidentiality of what they're sharing with you, and to ensure that they know that it's just in their best interest for you to have that information as their attorney and as their representative. And so I'll turn it back to Curry to talk about reasonable efforts.
Yeah, thank you. And I think, we do recognize that, like, having that approach maybe a little challenging, as Shruti mentioned. But I guess the reason, we encourage you to have this conversations is because even though presenting ourselves like using gender affirming, gender neutral language, or having a safe space sign, or all of those things are really critical, I've just seen so many things over the years where some bad stuff has been happening right under our noses as attorneys for children. And so having a more proactive approach is something I think we feel really strongly is critical to making sure that, clients are not suffering harm or mistreatment while in care. We're happy to talk with all of you more about that, and also recognize that sometimes your first meeting may be at the courthouse in a not great setting, or may not be totally private, or may be super stressful, or obviously thinking about your client's developmental age. There's many factors to think about in this, but we just encourage you to think about having that conversation about all aspects of identity, because we do know too that religion or not practicing a faith is often a real challenge for kids in care, but we aren't explicitly talking about that, or their experiences around race. And really knowing who our clients are in all aspects of their identity is pretty critical to being zealous advocates for them. So some other tips, and I know at least some attorneys in Georgia that I've talked to have really used this, using reasonable efforts as a way to really hold the agency accountable if they are not actually meeting, basic needs of your clients related to their identity or expression. So if healthcare isn't being provided in a timely manner, as it would for any other type of recommended care, these things are a barrier to permanence. Oftentimes with healthcare, we hear, oh, well, you need to be completely stable, and then we'll consider all of this, when actually having the healthcare that you need contributes to stability and reduces, again, suicidal ideation or self-harm or depression, and all of these things that, are really essential to well-being. So this is a tool, obviously, it's not a tool that we often like to use, but it may be an effective one to make sure that your clients are not being treated differently from their non-LGBTQ peers in care. Another common thing that I hear a lot around the country, and have heard in Georgia at times as well, is, well, we're sending this young person to residential care or a facility or a group home because we, quote, don't have a place that will take them because they're fill in the blank, trans or gay or whatever. And I really encourage all of you to be very zealous about doing a full diligence about whether that is in fact true. So, if you can do this where you practice, have a placement hearing. I recognize that some judges and the agency doesn't necessarily want to be told which specific placement to place, but if your client is being considered to be placed in congregate care because of a lack of a foster home, may be challenging whether that escalation in terms of level of care is appropriate. And in my experience in places, calling caseworkers or placement workers and really cross-examining them about what they've done and who they've asked and what efforts they've made to find a placement for this particular child, other than just looking at a screen with placement options or looking at a book or calling someone to say, like, do we have a placement right now? Like, it's incumbent upon us to make sure that kids are in safe and affirming places and not placed in situations where they don't need to be just because of who they are. So has the agency gone to a local LGBT center place? Have they gone to congregations that are affirming? Have they put out the word? Have they called everybody? Have they made extra or additional efforts rather than just your standard referrals? I think are really, really important, that we've turned over every rock to try to find a placement. What have they actually done in terms of kin, and have they offered kin options to be to grow, to improve, to have a conversation about whether they can be a placement? I think this is really, really critical. So, I know that it's challenging from an agency perspective often, and there's a shortage of homes and a lack of resources, but I encourage everyone to just not take no for an answer and make an extra effort, because the statistics that we know about LGBTQ exiting without a permanent home all track back to this. Like, are we making efforts for kids to be back safely with their families or in a home-like setting rather than letting them slide into congregate care and out to homelessness? So we'll get the next slide. Another big one, I think, is really thinking about, we know that oftentimes we're looking at what provider has a slot available or who's Medicaid, who takes Medicaid, like all these sorts of things. So we don't necessarily have the immediate luxury or ability to have someone with the best qualifications. But I think it's really important that we push back around that and make sure that we are not sending LGBTQ young people to evaluators, psychologists, therapists, someone doing a mental health assessment that has no experience working with LGBTQ folks, or is not willing to learn and consult with those who do. Because we all know that, like it or not, assessments and psychological evaluations often drive treatment plans and recommendations. So if we have somebody who is just oblivious to what the particular trauma or challenges or needs, healthcare, behavioral health, otherwise, that young people have, then we're going to be getting a lousy recommendation out of it that doesn't fit the needs of this child. So definitely push back on those things and demand that you have qualified experts, just like we would for any other, population that has some sort of particular need. Also encourage you, when you're hearing statements like it's our policy that in regard to LGBTQ youth, or licensing says we can't place a child consistent with their identity, that you sort of ask to see the receipts, like, where does it say that? What's the policy? Point to me in the code. Like, why is licensing saying that? Because unfortunately, we'll talk in a minute, Defects doesn't have an LGBTQ specific policy. The vast majority of places, there isn't actually a prohibition on licensing and placing kids consistent with their identity. So really, really push back and question when you hear statements like that, because you may find that actually there isn't a real policy, or it's a policy du jour, or that actually there isn't a barrier even where there's perceived to be one. In terms of pushing back against baked-in stereotyping, I'll use an example that, this perception that LGBT people are automatically dangerous and so can't have a roommate, or we can't necessarily have a gay young man sharing a room with a straight young man because, of course, something's going to happen. Like this idea that LGBTQ people are hypersexualized or dangerous, really butts up against, I think, the kind of, we have to really make sure that we're, over cautious about protecting people from harm, which is a good thing, of course, but it kind of butts up against treating people as automatically dangerous because of who they are, or, oh, you must automatically be a sex offender because you're expressing some sort of same-sex attraction to somebody, who's your foster brother, or things like that. I think are really kind of baked in stereotyping or discrimination in the system that we need to question. And just another thing for you to know, we'll talk about this in a second, like law, professional standards, social science have all got your back. So everything that we're suggesting that you do and advocate for, there is support on the safety, well-being, permanency front, best interest, strength-based, youth development on the juvenile justice side. All of these things are sort of tell us that if you affirm and support LGBT youth and they're able to be themselves, that they're way more likely to be healthy and well and successful. And that, after all, is what we're all about and trying to do here. Having your LGBTQ clients in court, if they want to be, and in your counseling role, encouraging them and having conversations with them to help them feel comfortable with doing that, can be a really powerful thing. It can also be a really negative experience if the court and the system and folks at court are not prepared and haven't done their homework and had their training. But I have definitely seen for clients who do feel comfortable being out and having conversations about what's going on with them in court, that it really can push the entire system to do better. That's a lot to put on your client, but then it's a lot for you to help them navigate. But when you can, really making sure that this isn't like, don't ask, don't tell, we're just all going to pretend all these things aren't happening, it, can really lead to some harm. So these are just some general tips for you to think about in terms of your advocacy. And we're going to shift a little bit to federal law and policy. And Shruti, is there anything else that you want to add?
Did we want to pause for any questions? Do we have any questions so far?
Yeah. So there are no questions in the Q&A at the moment.
All right,
great. We can carry along.
Yeah, so feel free to put any in if you have any. And we can pause again after some of the law and policy stuff just to see. Okay, so just talking a little bit about the federal law and policy, I think an important reminder that, everything that we know about the constitutional rights of kids in care and also the statutory obligations, both at the federal and state level, don't have an asterisk beside them that say, except for LGBTQ youth. So LGBT youth have all the same rights, that other young people have while they're in care. But sometimes we don't think about these in the context of LGBTQ youth. So youth have rights to relate their identity expression in terms of freedom from psychological harm, safe living conditions, adequate care, including services like healthcare. So when you're placed in out-of-home care by the state, constitutional implications arise. And so these are arguments that you can make there too. Obviously, we know that, unfortunately at times, LGBTQ young people in care bump into faith-based reasons for, harm, and whether it's emotional or physical or just a compulsion or pressure to practice a particular religion that isn't LGBTQ affirming. So that's another example of rights that you clearly have in care, which may be implicated. And of course, you have the right to equal protection. So being treated differently, as we mentioned earlier, compared to non-LGBTQ peers, has constitutional implications. And then basically just freedom of expression, while you're in state care, to express your identity or in exercise and protected speech, access to LGBTQ affirming supports in the community. All of these things are pieces that can have constitutional implications. Knowing as someone who has practiced in juvenile and family court, I realize at times, raising constitutional questions in the context of an individual case can really cause everyone's hackles to rise, but sometimes that is what needs to happen. And, bringing those things to the attention of a family or juvenile court judge, even though, everyone may need to have some more conversations and education about what those are, can be really, really critical. So again, all of the pieces about federal statutory and regulatory protections in the child welfare context to ensure that your safety, permanency, and well-being are met are also true for LGBTQ youth. I'll talk about the HHS grants rule in a second. The Affordable Care Act, Section 1557, prohibits discrimination on the basis of sex. As you all know, kids who are in care in the child welfare context, unless they are undocumented or some other reason, are all Medicaid eligible, receiving services from places that receive Medicaid. So all those protections attach. And also Title IX may offer protections in the context of educational programs that are offered while kids are in care. So Shruti is going to talk in a minute about some litigation going on around the Biden administration's interpretation of protections here in the wake of the Bostock decision, which established that in the employment context, sex includes sexual orientation and gender identity. But these are just some federal laws that you may be able to use at your disposal and have implications for kids in care. On the juvenile justice side, sex does appear as a protected class, both in the Juvenile Justice and Delinquency Prevention Act and under this Crime Control Act. So similarly, at having these protections attached from gender stereotyping, discrimination on the basis of sexual orientation and gender identity are arguments that you can make. And we encourage you all, if you are having LGBTQ young people that are facing disparate treatment or harm, feel free to reach out to both of us. We can provide some of this information about federal law and policy that you could put in motion, or help work with you on this, or if there are judicial officers out there that would like information about how this applies to child welfare and juvenile justice settings, we're happy to help. So just a bit of an update, as we mentioned, some of the things that we do are litigation at the federal level. During the prior administration, HHS announced that it was not enforcing the non-discrimination protections in the HHS grants rule, which include sex, sexual orientation, gender identity, and religion as protected classes applicable through funding that flows from HHS and their grants to state child welfare agencies. So they decided not to enforce that. That has not been lifted, even though we have filed a lawsuit and asked the current administration to lift that decision. That's still in place. The prior administration on the way out the door also issued a rule, a new grants rule, pulling sex, sexual orientation, gender identity, gender expression, or gender identity and sexual orientation as protected classes from the HHS grants rule. We filed a lawsuit on behalf of a number of organizations, including Foster Youth and Alumni Organization in Alaska. The effective date has been stayed by agreement with the Biden administration. So the 2016 grants rule is still the law. There's just currently this non-enforcement decision in place. And I think HHS is going to be issuing a new rule, but the rule guiding the protections has not become law and the effective date has been stayed. Also, the prior administration did issue a rule pulling the requirement that child welfare agencies collect sexual orientation data elements and a number of elements related to implementation of ICWA. We filed a lawsuit challenging that and the process of trying to sort through whether we're going to litigate or settle that case with the current administration. So back to our data collection thing, that we were going to be in a place where states were going to be collecting, of course, if young people voluntarily disclose if they're 14 and over their sexual orientation, and for foster and adoptive parents and guardians, but that has all been stalled out because of a new 2020 rule. that we're litigating. So other proactive reform at the federal and state level, many of you may have heard about the Equality Act, which would bring sexual orientation and gender identity as protected classes to civil rights laws nationwide, and would apply to government funded services. So that would apply to the foster care system. There's a separate Every Child Deserves a Family Act that is specific to child welfare services. Both of those are pending in Congress as we speak. And then I know through just contacts with a number of folks who are kind of working with Georgia DFACs at the moment, that they are working internally and having discussions about LGBTQ policy and developing a non-discrimination policy, and have been having conversations about practice, knowing that at the moment, without policy and practice guidance, that young people in care are very dependent on the individual person that they get, or supervisor, or where they live in the state, all those sorts of things. And of course, a lot of inequity baked in with that approach. So it's encouraging to hear that DFACs has been working on this, and hopefully it'll move forward. Many of you may have heard all about the Fulton v. City of Philadelphia case, a Supreme Court decision from this summer that I think initially the ask by Catholic Social Services, the plaintiff in the case, was really to allow for a widespread religious exemption in the context of non-discrimination laws, in this context, foster care. The Supreme Court did not do that. It was a very narrow decision based on contract language between the City of Philadelphia and Catholic Social Services. So basically what happened is the city found out that one of its contractors was refusing to license same-sex couples as foster parents. That particular contractor agreed to do so. Catholic Social Services was asked whether they do. They said they refused. Philadelphia said they could no longer continue to contract with them. Catholic Social Services sued, claiming that their free exercise of their religion and speech was violated. The court ended up saying that because in the contract the City of Philadelphia had with Catholic Social Services, there was an exception that allowed the Child Welfare Commissioner to grant exceptions to the non-discrimination requirements at her discretion, that took the whole case out of the analysis under the Employment Division v. Smith case, and meant that which says that non-discrimination requirements have to be generally applicable and neutral. So then the city had to show that it was passing a strict scrutiny test, and the Supreme Court said it did not meet that. It's kicked back down to the lower court, and remains to be seen what Philadelphia is going to do, if they're going to sort of cure these deficiencies or what's going to happen. But in the meantime, Catholic Social Services is allowed to turn away same-sex couples. So different sex couples in Philadelphia have access to every agency. Same-sex couples don't. I recognize that there are agencies in Georgia that receive government funding that refuse to license same-sex couples. So I think a major issue for LGBTQ youth in care, and thinking about these lack of placement options for them, and also just having a system that really sets up discouraging people who aren't of a certain faith or are LGBTQ or part of a same-sex couple from really, having every agency at their disposal, just like folks who are not LGBTQ or of different faiths or of majority faiths do. So you may be hearing, more about this as it pans out, like in the federal courts and in terms of practice and policy. But the good news is that the Supreme Court did not grant a huge exemption or exception. And this was a very narrow decision based on the contracts in Philly. So the general right for governments to establish non-discrimination principles that are generally applicable and neutrally applied still holds. Okay, so just briefly, Georgia law and policy, specifically on the child welfare and juvenile justice fronts as it relates to sexual orientation and gender identity, is unfortunately slim. As far as we could find, Georgia has no explicit statewide protections from discrimination in the context of the child welfare system. As I mentioned, I know DFACs and a number of advocates in Georgia have been working on this issue, on improvements on the policy front. And I know they put out a great guide around affirming LGBTQ youth and families a couple of years ago that if you don't have a copy of that, we can make sure that you do. On the juvenile justice front, better news in that Georgia DOJ does have a specific policy for LGBTQ youth that was developed in 2015. So maybe they're working on an update because a lot has changed for the better then, but it's fantastic that they have that. And really, it's kind of a lot of these policies, specifically the juvenile justice system, have taken the floor of the Prison Rape Elimination Act requirements to recognize that LGBTQ youth and adults in correctional facility settings are at a higher risk of victimization and harassment, and have really taken that up to a more strength-based affirmation of name, pronouns while in care, making sure you have access to healthcare, like all of these sorts of things. So, if you weren't aware that this policy exists, there's a link and check it out. If you are having clients who are having challenges around how they're being treated or their safety while in care, please reach out to us and let us know. We're happy to help. But it's great that Georgia has that policy in place on the juvenile justice side. So I'm going to turn it over to Shruti to talk a little bit about some of the social science information that I referenced.
Great, thanks, Curry. So in working with LGBTQ youth, one important tool that we have beyond the state and federal law that Curry just spoke about is the support of social science. So while attorneys for children may hear from courts or providers language such as, I don't know about all this, it's all so new and edgy, we can't accommodate this, or, the terminology and identities keep changing. The social science is very clear, and it boils down to one point. The affirmation of gender identity and gender expression for a child is good, and it undoubtedly improves a child's well-being. So as attorneys for children, you know that the social science has your back when you're advocating on behalf of trans and non-binary youth. When it comes to best practices with placement, healthcare, names, and pronouns, you have all the support from social science backing you, because well-being is one of the core obligations of states to children. And so, as you can see on the slide, the generally accepted treatment protocols for gender dysphoria have been aimed at alleviating the distress associated with the incongruence between gender identity and birth assigned sex, rather than to force an individual to live in conformance with their natal sex. So basically, accommodating a child in their identity and making sure that you understand that affirming them at all levels of their identity is best for their well-being, like their social outcome, their mental health, their physical health, knowing that things as simple as placement and healthcare and calling them by their chosen name and using the pronouns that they identify with undoubtedly leads to improving their overall outcome is key to representing LGBTQ youth to the best of your ability. And in terms of organizations that have backed the social science, all of these agencies have all said to the Supreme Court that affirming a young person's identity and allowing them to be themselves and live authentically leads to the best outcomes for them, which is, at the end of the day, as Curry mentioned, our purpose is to make sure that they achieve the best possible outcome they can while in care or in the custody of the state, especially. Again, we spoke about this several times during the presentation, but I think for good measure, it's important to say it again. You can make an enormous difference by making sure your client's name and identity are respected. You may think of a name as something so small, but this makes such a difference to the young person's life. You may be one of the only people in their lives who is affirming them and not using their dead name, for example. You may be one of the only people they confide in about how they identify. So, creating this safe space as you're creating an attorney-client relationship is super important, as it's rooted in trust, and it shows your client and the child that you're taking the time to understand them and affirm their identity, and that in itself is a level of respect between you and your client. And, as you can see on the slide, youth who are able to use their chosen names have the lowest levels of depressive symptoms, suicidal ideation, and suicidal behavior. And an increase by one context in which a chosen name could be used predicted a 29% decrease in suicidal ideation and a 56% decrease in suicidal behavior. So, this simple act of affirming their identity by using their chosen name can go so far with respect to the well-being of a young person. And so making sure that in your practice you incorporate, as we spoke before, the introduction practice of making sure that whatever names on their court documents or other legal documentation you've seen, making sure that that's actually how they identify and that they don't have a name that they actually prefer to use as opposed to what they were given legally. And so it's just another plug for making sure that identity is at the forefront of your interactions with your client. So, Curry, if I want to pass this back to you.
Yeah, I mentioned earlier just a little bit about family acceptance and the important, and just wanted to, in the context of the specific discussion about trans and non-binary youth, of just the impact on family support and what that looks like, whether that's family of origin, foster family placement, that really providing some concrete information and support, education, therapy, like whatever it takes to get to this point, really has dramatically improves young people's outcomes. And also just wanted to flag too, in the context of names, that we know and hear a lot about folks, both attorneys for children and from judges and magistrates, about this question of using a young person's name that they go by in court versus their legal name. And we recognize that unless a young person has changed their legal name, that there's going to be that name on a court docket. But I'm not aware of anything in any state or jurisdiction that requires that, then with the young person's permission, of course, that using that name in reports that are the name that they use, and reports that are written in conversations in court, and all of that is impermissible. And in fact, all of the reason we're sharing all the social science and information about names is because, since we are focused on well-being and best interests, that all the data points to all of us affirming that identity and allowing that young person, when they're ready and when they want to, in court settings and in reports and in all aspects of the system, to have that name reflected, really is good for them, and that should always be our focus. So in a court report, for example, you can say, Susie Smith, and then in parentheses, legal name, whatever, and then refer to the child as Susie throughout the rest of the report. If you need to do that to acknowledge the discrepancy between the caption, for example, and the language in the report. So just a practical thing that I know has come up in a lot of courts and everything. And I think that's true from the agency side, referring internally and making sure people are consistent with using the name of the child all the time is really helpful for them. So I'm going to turn it back over to Shirley to talk a little bit about kind of what's been going on in the broader world in terms of attacks against trans and non-binary youth across the country, because it's having some repercussions, of course, for young people, but also in the context of the child welfare system specifically.
Yeah, I know we've given you all a lot of information today, but it would be remiss of us to not address what's going on across the nation. I know many of you may be following the legislative assault on trans youth that has taken place over the past year. I think it's important to understand, why this is happening now and kind of where it stemmed from. So, we had the Obergefell decision in 2015, which granted the right to same-sex couples to get married. And post that decision, we saw the first wave of anti-trans bills, and we can call them the bathroom bills. These bills, 2016, 2017, you have Gavin Grimm's case, and what we saw is that these bills started to fail in the courts and in practice. We have circuits such as the Fourth Circuit that staunchly supported allowing trans students to use bathrooms that align with their gender identity. And at the end of 2019, early 2020, we saw the anti-trans movement pivot from bathroom bills to two bodies of bills. We call them the healthcare bans and the athletic bills. Things that may have caused this shift, as Curry mentioned earlier in our CLE, that Bostock was decided in the summer of 2020, which basically said under Title VII, employment discrimination, sex discrimination includes sexual orientation and gender identity discrimination. So between that amazing decision for the LGBTQ community and Joe Biden being elected November 2020, the debate of trans existence kind of fueled all the actions that we're seeing at the state legislature. And it's, an enormous amount of opposition that's coming towards these young people and, just their ability to live safely and authentically. And so, Curry, if you mind. Yep, thank you. So over 100 bills were introduced in 2021 alone targeting trans youth. And as I said, these bills fall into two main categories, the healthcare bans and the athletic bans. Both bans are incredibly harmful in their own respect. The healthcare bans essentially prevent trans kids from obtaining life-saving gender-affirming care. Some of these bans even aim to criminalize providers of gender-affirming care, whether they're mental health providers or doctors. And we're seeing this legislative battle unfold in Texas right now with respect to whether providers can face criminal charges for providing gender-affirming care. And with respect to the sports bans, as we've said throughout this whole presentation, like affirming a child and providing them the opportunity to live safely and authentically leads to good outcomes for them. And school participation is undoubtedly tied to social and emotional well-being. And these laws deprive trans kids of the opportunity to be kids and to play with their classmates in schools and form meaningful connections with their classmates without having to worry about their ability to play a sport on a team that they align with. And so we're seeing these battles play out in litigation in several states. And so I want to talk about two wins that we've recently received those. So in terms of the healthcare bans, the ACLU sued in Arkansas, and that was in July 2021 that we received a favorable decision that secured a preliminary injunction from the Arkansas health ban from going into effect. And there are proposed bans in several states that would deny over 20,000 trans young people care. I just wanted to say that number because that is an enormous number of kids who are at risk of losing the healthcare that they rely on. When the Arkansas bill passed and turned into law, just that week, there were 7 kids that we knew about that had attempted suicide that week as soon as that bill was passed into law. And so it's really horrible to see the consequences of these bills and these eventual laws on trans young people and just how they view themselves and how they view their ability to continue living authentically and safely. And the prohibition of participation in school sports, we see there are 9 anti-trans sports bans across the country, and there are temporary injunctions blocking the Idaho ban and the West Virginia sports ban. And I'm going to tell you a little bit about the West Virginia case as a case that I am currently working on. And so Lambda Legal, along with the ACLU of West Virginia, and a law firm called Cooley, sued on behalf of Becky Pepper Jackson. You can see her on the right there. She's an 11-year-old trans girl who's looking to run on the girls' track team at her school. And Becky had already been on the girls' cheerleading team for 2 years, but HB 3293 was signed into law this past April, and it bars trans girls from playing on girls' teams, but it does not affect the ability of trans boys to play on boys' teams. The law harmfully defines biological sex as an individual's physical form as a male or female based solely on the individual's reproductive biology and genetics at birth. And so we made 2 arguments as to why this law is unconstitutional. And our preliminary injunction motion, as I mentioned, was granted. And so I want to tell you a bit about what the court's reasoning for siding with us was. So first, we argued that the law violates the 14th Amendment's equal protection guarantee. And this is because the law discriminates against trans girls and only trans girls, and cis boys, cis girls, and trans boys are all unaffected by the law's central tenet, which is that non-cisgender girls may not participate on a girls' sports team. And so the court found that the state of West Virginia's argument fails because plaintiff is not most similarly situated with cis boys. She is similarly situated to other girls. And this language is immensely helpful for us because it, confirms the narrative that trans girls are girls and trans boys are boys. And we also argue that the law is in violation of Title IX, and the court agreed with us on this front as well because Becky is treated worse than other girls with whom she is similarly situated because she alone cannot join the team corresponding to her gender identity. The court went on to say, that BPJ is being excluded from school athletics on the basis of her sex is clear. And so having found at the preliminary injunction stage that Becky was likely to win on her Title IX claim and her equal protection claim, the judge ruled that at this point, I've been provided scant evidence that this law addresses any problem at all, let alone an important problem. We're now in the motion to dismiss stage in that case. And, the collective arguments from the defendants are that they're not responsible for the law and therefore they can't provide Becky with any relief. And so we're hoping to continue with this momentum that we've had from our PI decision. And Becky actually was able to try out for the track team and made it on the track team. And so we're very happy that she has not been hindered in any way yet in her participation. But even with all the wins that I've just mentioned to you, Arkansas, we have Idaho, West Virginia, the opposition is relentless. And we see a strong anti-trans youth coalition forming among the states. So I think Curry mentioned this suit earlier, but I'll give you a bit more detail right now. So on this past August 31st, attorney generals from 20 states sued seeking to halt directives that extend federal sex discrimination protections to LGBTQ individuals. So as we mentioned before, Bostock was in the context of Title VII, and it ruled that sex discrimination includes sexual orientation and gender identity discrimination. What this complaint is essentially seeking to do is make sure that Bostock is not extended to Title IX to kids in school and specifically trans kids in school. So the complaint seeks to avoid that extension from happening, but also the EEOC and the Department of Education have put out their own guidance, wanting to make sure that trans kids and LGBTQ kids at large are protected in schools. And the complaint seeks to remove that federal non-discrimination guidance that was issued by them and seeks a particular belief, a particularly heinous relief. So the plaintiffs seek declaratory judgment from the court as to several issues. They want to secure from the court that the EEOC document and the ED interpretation and fact sheet, these guidance documents that they had put out, were disseminated without authority, that Title IX recipients may separate students by biological sex in appropriate circumstances, that Title IX does not prohibit recipients from maintaining separate showers, locker rooms, bathrooms, or facilities based on biological sex, and that Title IX does not require a Title IX recipient's employees or students to use a transgender individual's preferred pronouns, among other relief that is incredibly harmful to young people, and specifically trans and non-binary young people. And so what we can glean from this is that, the battle is long from over, and that what we need to do is to implement all the things that we've discussed today in terms of affirming a young person's identity and making sure that we do all that we can to protect them from discrimination at all stages. And we will see how this particular suit plays out, but that's why the work that y'all are doing is extremely important. And what we can do going forward is just to make sure that we do the best job that we can in affirming and representing our clients and affirming their identities, whether it's, in your conversations with them, whether it's in courts or, in their state's custody, if they're in the child welfare system or in the juvenile justice system, making sure that they don't experience discrimination in those places. And so I will, leave it open for questions. If anyone has any questions, and they feel free to unmute yourself or drop in the chat box if that's how this Zoom works.
Yeah, and Also, and so before you jump in, I wanted to also mention that we have been focusing on specifically around experiences while in child welfare and juvenile justice settings, but to Shruti's point of like what's going on in the world generally, like we know that this harmful legislation and harmful messages about you can't be who you are or you are a second-class citizen, that those two impact all kids, and kids are paying attention like to those messages and they have negative impacts. And also that our clients, like in child welfare and juvenile justice settings, don't exist just in those settings, they exist in the world, right? So they may be having challenges in school related to who they are, how they express themselves, or in their community, and real questions of safety. We know that particularly like trans women of color have just unbelievably high rates of like interpersonal and community violence. So navigating getting to that appointment on the bus or something like that can be a real challenge for clients too. And then also that identity documents, that if you are able to get your name legally changed or have your driver's license, if you're an older young person, adjusted so it comports with who you are, like all those things are really important aspects of safety in the world, but may not be something that you personally can do in your role as appointed by the court. But I encourage you, if your clients are facing challenges while in care or out, to call our help desk, or you have my email, and Shruti's in Anissa knows how to reach us. So if you want to reach out about those things, there are some programs that will assist clients who the gracious pro bono work of like firms in Atlanta to help with adjusting identity documents. There are questions around schools. We handle those things or can refer to a cooperating attorney. So we just want to make sure that we understand that there may be some limits to what you can do, but there are resources out there if your clients are experiencing discrimination in other aspects. And one final thing I'll say is that also recognize that on a day-to-day, like with high caseloads and just a general workload, that filing a grievance or making a complaint up the chain about the experiences of your client may be hard to do, or maybe through your advocacy you get that individual situation resolved. But I really encourage you to shoot an email to the head of defects or to someone who takes grievances or ombudsperson or the supervisor, wherever you are, and let them know about what's happening. Because we hear constantly across the country from policy folks who say like, well, we're not hearing about this. And I think given everything we know from years of studies and information about the challenges around LGBT youth, that you have an obligation to find out what's going on. But I do think that sometimes policymakers don't hear about what's happening, so they don't have an idea of the systemic nature of the problem. They don't have an idea of the breadth of the problem. And then also feel free to reach out to us, because we are pushing HHS to pull this non-enforcement decision, and their Office of Civil Rights plays an important role in ensuring that kids and families are treated equitably and are safe. So if you have clients that are not being treated right, let us know. We can consider working with you and them to file a complaint with HHS OCR if that's appropriate. So I just mentioned all those things that like we are play our role, in direct advocacy, but also in pushing the system to do better. So I will stop there and let Anissa take back over.
So we have a few questions and not posed to anyone indirectly. The first question is from Sharon Blake, and she writes, I need a list of psychologists for referral for LGBTQ kids whom I represent. For example, I am preparing for a DF hearing, designated felony, and I may need an independent evaluation to show that perceived discrimination by the child caused her to pull a weapon on a school official. DFB is 18 months max and 3 years DJJ probation. I am trying to limit her restrictive custody to more than 90 days. In addition, I need a group home that specializes in LGBTQ youth.
So this is where it's really awesome that we have an Atlanta office and folks who are really familiar there with some resources in the state. So feel free to shoot Shruti and I an email if you have time, or maybe Anissa can let us know, how to reach you, and we can definitely try to get that information for us. I know there are a number of qualified providers, in the state. I don't have that off the top of my head. We can definitely get it to you. And I think you bring up a great point that, this whole question of whether you've been experiencing discrimination, your response to it, can be extremely relevant in the defense, of your case, or also in the disposition. I know that there is at least like Chris 180 in Atlanta, I know has a history of doing a lot of great affirming work and has some group homes. I'm not sure whether they also accept young people who are involved in juvenile justice cases and not child welfare, but they are a good option that I know of that has group care. Also, I think sometimes by having places that specialize in LGBTQ youth, we have let a lot of other group home care providers say, oh, we don't do that, or don't have them here. So obviously we don't want to put kids in an unsafe situation. But I think also it's the obligation, of the state to make sure that all of their programs are affirming and supportive. So something to think about too, as you're, navigating what the options may or may not be.
Okay, and Cindy Wang stated, not a question, but a comment. She states, not a question, but just wanted to let everyone know that we have been updating the policy and can provide the most recent version to anyone who would like it. And that she is general counsel for DJJ, and she was referring to, I believe, Mr. Cook, you said something about the DJJ policy from 2020, the 23.3 is what it was.
Yeah, from 2015, I think I mentioned wondering if they were updating. So thank you, Cindy, for mentioning that you are. That's awesome.
And Joel Thornton writes, can we get the references to the 2018 study you referenced on name and pronoun usage?
For sure. Yeah, we're actually in the process of updating a PDF that we have, which has like a bunch of the links to some of the studies that we reference, and just gathering up some new ones. Thankfully, we're getting, really good and important research, more and more focused on LGBTQ youth, both in systems of care and out. So we're in the process of updating that, and we can get it out to Anissa to share via the section of the bar.
And it looks like those are all of the questions. JP did add some of the language from that DJJ policy in the Q&A. I believe, I don't know if he meant to put that in for chat or if he wanted me to read all of that, but it's basically the language from the DJJ that does protect LGBTQ plus youth. But does anyone have any more questions that they would ask? Oh, something else popped up. Oh, just need to share. Okay, that was JP. I have a question, if I may. This may be on some people's minds. So Mr. Cook or Ms. Swaminathan. Okay.
That's great.
Thank you. So I know we're talking about what happens if DFACS is not providing the services that are recommended by a medical professional. They're not trying to identify supportive homes for our children. And you touched on like reasonable effort, finding a no reasonable efforts finding. Are there any other suggestions that attorneys or legal advocates can seek with the court here in juvenile court that might have some teeth in them?
Yeah, I mean, I guess one of the things that I encourage folks to do, depending on where you practice and how this works, and I say this knowing how challenging it can be with a huge caseload to do this, but I do think calling witnesses, whether it's the caseworker or supervisors, or even like people way up the policy chain, about like what the policy is and what they're doing or not doing, can really expose these systemic failures that actually there isn't guidance and they're not actually treating particularly medical behavioral health care in the same way for LGBTQ youth, particularly trans and non-binary youth, as they are for other young people. Like we don't we don't even hesitate for a minute to think if somebody needs a provider who has a particular expertise or qualification, of course we would refer young people there. We want them to receive the best medical care they can and the best qualified care, but oftentimes gender affirming care is treated completely differently, and there is no reason for that. So I would just encourage like calling witnesses, asking for production of documents, like getting discovery, like getting a specific list of like referrals that's made, who was contacted, figuring out, well, if Medicaid won't pay for X person, well then, every state has a pool of funds used for situations where Medicaid doesn't reimburse for whatever reason, or can appeal. So I think those are some questions to ask. And again, raise the constitutional implications of not providing medical care to a kid who's in state custody. Like they're there. Shruti, I don't know if you had any other thoughts.
We just got a new question in. It's from, I believe, Veronica Royals. And she asks, who are you working with to update policy and defects so we can be a part of that conversation?
You know what? I have been like on a couple of email chains with folks, but around that. So let me find out like the names of those folks. I can't remember them off the top of my head. And then also a wonderful colleague of ours that Anissa knows, Christina Remlin at Children's Rights, has been a part of those conversations, both in the context of the Kenny A settlement and also just generally. And a wonderful person that Shruti and I work with, Elliot Hinkle, who just did some consulting with DFACS and has been working with them. So let me find out and we can, figure out what the opportunities are to be involved and give input.
Are there any more questions? I believe we're reaching almost our time limit. Are there any more questions? Well, I believe that is all. Did you have any parting words you wanted to share with us? Oh, I'm sorry, something just popped up. My goodness, I'm moving too fast. Okay, it says, would you please confirm email address? I think it is missing a D. I'm not sure which one.
Oh yeah, you're right. Yeah, it would be good if I had actually written our email addresses correctly. So you're right. Thank you, attentive participant. Yes, it's LAMBD. Also helpful if we spelled my own organization's name right. Yeah, LAMBD. Hey, also lambdalegal.org, not lambda legal.org. Sorry about that.
So good eye, anonymous.
Yes, good eye and bad proofreading skills on our part. So thank you.
Are there any further questions? We have I think we have about a minute or so. 2 minutes. Any other questions? Well, any parting words, co-presenters? I love you guys so much. Anything you want to share with us?
I don't think so. Just want to thank you so much for all of you participating over your lunch hour. We know how busy you all are, and for Anissa for reaching out, and for the Georgia Bar to allowing us to present and talk about this topic with you. And we'd love to continue the dialogue and provide any assistance and support we can to you all as you advocate for your LGBTQ+ clients. Thank you.
Yeah,
thank you all
so much. I'm grateful for an opportunity to talk about LGBTQ youth in particular as well, because I feel like that's a less talked about subject. So thank you so much for your attention and for your questions.
Wonderful. I think that concludes our session. Thank you all for coming, and the webinar will be made available on the Georgia Bar site for those of you who missed it. And again, thank you all for coming. That concludes today's session.
Ladies and gentlemen, this does conclude today's webinar. Thank you for joining and have a great afternoon.